Okay, today we're going to cover a little bit of information. We're going to go from 3.5 to 3.7. And kind of what we want to talk about today is center our discussion on the Second, Eighth, and Fourth Amendments. So, Second Amendment, the right to keep and bear arms. We're talking about guns here. The Eighth Amendment, the idea of no cruel and unusual punishment. And the Fourth Amendment, protection against unreasonable search and seizures. Now, when you look at these cases, 2, 8, and 4, Supreme Court cases that deal with these amendments, so 284, what they provide is a delicate balancing act when the court looks at cases that deal with this. And what I mean by that is the balancing act is this: it's individual freedoms versus public order. So the idea would be, what is acceptable in regards to rules and regulations that restore public order, and what is overboard in regards to individual freedom. So I probably didn't say that right. So here's what I'm going to say. All right, look at the Second Amendment. All right, promoting public order would be gun control, background checks, keeping the guns out of a lot of people's hands. But is and are those actions restricting individual freedom? So you kind of see the balancing act of what they're looking at, and it's either one or the other. Or the Eighth Amendment, which is this, is imposing the death penalty, if you will. Is that promoting public order, or is it infringing upon people's individual liberties? In the Fourth Amendment, the same thing with digital spying by our government after 9/11. Is that promoting public order? Is that acceptable? Is it necessary, or is it infringing upon our liberties? So that's the delicate balancing act when you look at those things as well. Now, just a general narrative. Over time, some of these have kind of changed. The rulings have changed. As the courts changed, as the people on the court change, sometimes the ruling will change. But I'll tell you, since the 1960s, the Supreme Court has been behind gun owner rights, okay, with little restriction from the federal government. That's kind of been the narrative too. Now, with the Eighth Amendment, it's changed, okay? So this idea of cruel and unusual punishment, the death penalty is mostly associated with that. It's evolved over time, and so we don't execute minors, or we don't execute people who are legally judged to be mentally incompetent. So we don't do that. Now, the Fourth Amendment is the one that is the most recent one that we've talked about. So after 9/11, the National Security Agency, along with the FBI and CIA, were in the business of preventing another terrorist attack on American soil. So their solution was to collect metadata. So metadata is just a fancy way of saying data about data. So they weren't taping phone calls between the average everyday Americans, but what they were doing was collecting who you were calling or looking at internet searches. Those things were logged, those things were stored and used by the NSA to detect future terrorist attacks or terrorists in America as well. Now, when Edward Snowden blows the lid off this thing, you have the two parties that come about. The ones that are cherishing individual liberties, which is, hey, this is ridiculous. It's the government overstepping its power here. The NSA didn't tell the American public they were doing this. It wasn't out in the open. These are warrantless searches. So there's your individual freedom people. But on the other end, then you had the promoting public order people, which is this idea of, okay, well, if you want to protect America against a terrorist attack, here's how you have to do it. Here's the necessary means you must do. So you see the balancing act of, we should do this. No, we shouldn't. Yes, we should. No, we shouldn't. So I'm going to attach an article to this post that really talks about this a lot. And does probably a better job than what I could explain. Now, the last part of these, specifically Amendment 2, is this idea that it involves selective incorporation. Now, I'm going to read this because it's a long-winded, really, really long definition, but it kind of tells you what it is. All right, so selective incorporation is the process by which the Supreme Court, using the 14th Amendment, specifically the Due Process Clause, has applied a majority but not all the Bill of Rights provisions to the states on a case-by-case basis over an extended period of time. So here's what that's saying. All right, in the beginning, here's what it looked like. In the beginning, when the Bill of Rights is passed, the Bill of Rights only applies to the federal government. So average everyday citizens were protected against government intrusions upon Amendments 1 through 10, but the states didn't have to live up to those standards, okay? Nothing was said in the Constitution where the states had to respect rights like, freedom of speech, the freedom to assemble, and so on as well. So the cartoon shows you that the federal government is wrangled here, but the state government's like making faces at them and hollering at them and whooping and making jokes and so on as well. With the 14th Amendment, it's the first time in the Constitution that you see the word state. And it says, no state shall deprive its citizens of privileges and immunities due process and equal protection of laws. And so what that eventually does is what that says, okay, the Bill of Rights only applied to the federal government in the beginning, but guess what, states? Now it applies to you. And so what selective incorporation is this. It's right here. Now, before we even move forward, you do not need to know all of these cases. You do not need to know. A couple you would. McDonald versus Chicago would be one. Roe v. Wade is not on here, but it's another one that could apply to it as well too. But look what's happening here. All right, the Bill of Rights provisions: speech, press, assembly, religion. The Second Amendment: bear arms. Third, no quartering soldiers. Okay, and reasonable search and seizures. Now I told you that it's over an extended period of time. Look, an extended period of time. All right, it just doesn't happen in 1 year. It happens over an extended period of time. And it's done on a case-by-case basis, all right? Notice that the First Amendment, which has the 5 provisions right here, okay, each one was a specific case. So speech was Gitlow, press was Neer, assembly was DeJong, religion is Cantwell. So it's on a case-by-case basis. It's just not one case involved every single protection in the Bill of Rights, specifically the First Amendment, and it incorporated everything, okay? So it didn't. Now, the one thing that it does do, all right, is that it sets limits on state power. And here's what I mean by that. Beforehand, if a state had a rule or regulation restricting speech or the press or the freedom to assemble, they no longer do after this. So when each one of these court cases is passed, think of it like a little chip off the power of state governments. You're no longer to restrict speech. You can't take away press and assembly and so on as well. Now, it's called selective incorporation because not all of the provisions and amendments in the Bill of Rights have been incorporated. Like, look at number 3, no quartering of soldiers. It's not incorporated, okay? States don't have to live up to this standard. There's been no case that has applied the Third Amendment to the states and so on as well. And if you go down here as well, I'm sure there's, down here, number 7, the civil jury trial. That's also not incorporated. So it's selective. It's not a majority. It's not everybody. It's a majority, but not all. All right, it's a majority, but all. Hence the selective incorporation. So that's what we're looking at. Now, I will tell you this: with a lot of these cases right here, when you go right down the line. Welcome to individual freedom versus public safety. A state promoting public safety in the form of a law or a restriction, and people arguing that their individual freedom was violated. All right, so when you have this situation, all right, we have this dynamic, this balancing act. That's where the Supreme Court comes in. Okay, and that's where the Supreme Court says, okay, are states justified with these measures of promoting public safety, or do individual freedoms win out? And the most recent one is McDonald versus Chicago, which the right to bear arms in 2010, where it ruled a provision of Chicago unconstitutional. It felt the government overstepped its bounds with the restrictions of guns and sided with gun owners. So from here on out, states, you will respect the rights of gun owners. Now, I will tell you this with gun rights moving forward. The one thing that McDonald versus Chicago does do as well is kind of say, okay, states, you got to respect this right, is at the very end of that ruling, it also says that, hey, in the future, the government or the courts might look kindly upon reasonable regulations, okay? We're not about completely eliminating every single gun control measure you can think of. That's not what this ruling is. It's just about one specific ruling, one specific law provision that took place in Chicago. But moving forward, we understand that states and the federal government might have, reasonable restrictions, and we're going to get behind them. We're going to support that. So that's where it goes from there. All right, so there it is, 3.5 to 3.7. If you have any questions, concerns, or comments, always feel free to email me at any point in time. I'm going to leave these notes as well as that article that deals with the collection of metadata on this post as well. I'll post a couple of AP questions on AP Classroom. Those are only practice. The big thing that you need to worry about this week is that FRQ, that concept application FRQ. That is due on Sunday, and it is mandatory that you do that. So, without further ado, have a wonderful day. We will see you tomorrow.